Okay, the recording's been started, and when you're ready, Carmen, if you share your screen, we'll be ready to go.
Okay. So this is Carmen Sanchez from the Office of Special Education Programs, and this is a webinar for all the parent centers that we fund. We're going to be starting in a moment. For those of you who just joined us, I want to draw your attention to a couple of things in this program. One, you'll see a question pod in your controls. That's where you can ask questions. We will not have anybody unmuted. You'll have to ask the questions through the question pod, and we'll answer them as we go along with the webinar. Secondly, if you want to just send say something to us as presenters, you can use the chat space, and then only the presenters will be able to see what's in the chat space. Third, there is a control called handouts. You'll see that there's a number 1 next to the handout. If you click on that, you'll be able to download today's PowerPoint, and you can have it for your own use. So I just wanted to draw your attention to those, several of those things. And I'm going to start sharing the screen in my screen in just a moment. Okay. For some reason, Jennifer, I can't seem to be able to do the screen. Do we need to change presenters to me?
Let me see here. Attendees, staff. I am going to make you presenter.
Okay.
And you should be able to do it now.
Yep, just did.
There we go. Perfect.
Okay. Okay, let me start the slideshow. So again, this is the OSEP quarterly call, or in this case, a webinar with the parent centers. Today's agenda, we're going to give you a little bit of updated information on the Every Student Succeeds Act, or the ESSA. It's not so much information, it's just I want to highlight for you the information that's publicly available on the web, and so you can bookmark it and refer back to it. Then we're going to have 3 presentations on important pieces of guidance that have come out from the department. The first one's going to be about effective communication in public elementary and secondary schools. The second will be on the notice of proposed rulemaking on significant disproportionality. And lastly, an overview of the state correctional educational self-assessment tool and guidance around the use of that tool. So those are the things we want to highlight for you. So when you want to get information about the Every Student Succeeds Act, I think most of you have visited the website, but I wanted to draw your attention to where it can be found. And it's very easy to remember the URL. It's just www.ed.gov, then /ESSA. This is what it looks like on the front. If you keep scrolling down, you'll see that you'll have a bunch of new resources on the side, including committee materials. As was mentioned in the last webinar when Ruth Ryder and Leslie Clitheroe talked about ESSA, they talked about how some portions of it will go through a negotiated rulemaking process. So that has already started. We had the first meetings Monday through Wednesday this week, and there'll be a series of meetings. And so that committee has been formed, and there's materials having to do with that committee. There's also some new frequently asked questions that they keep getting added to about transitioning to ESSA. And so you can look at all of those. You notice that the third link, check this web page for key ESSA resources. I'm just going to show you what that looks like. You'll see it here. This is a whole bunch of resources having to do with the Every Student Succeeds Act. And again, if you scroll down this page, you'll notice again that there's public notice about regional meetings, and there's a lot of information about negotiated rulemaking, what are the protocols for the process, who are the people who are on as non-federal negotiators, session materials, etc. So I really encourage you to bookmark this part of our website and stay on top of what's going on around the reauthorization of the Every Student Succeeds Act, because as you know, the children who receive special education services also receive general education services, and therefore this also affects them just as much as kids who don't get special ed services. So with that, I'm going to then hand this over to our colleagues in the Office of Civil Rights, Ann Hoogstraten, and also within OSEP, Laura Duoff, and they're going to talk about a bunch of guidance that came out around effective communication in public elementary and secondary schools. So Ann and Laura, can you take it away?
Sure. Thank you, Carmen. Ann and I will be discussing the effective communication guidance that was issued by the Departments of Education, and that was OSERS and OCR, and the Department of Justice on the rights responsibilities under the IDEA and the American with Disabilities Act regarding students with hearing, vision, or speech disabilities, and specifically the effective communication requirements in the ADA. Next slide, please. So just quickly, this presentation, this is just general information. It is not a complete recitation of all the law and policy, and we don't address specific issues of compliance because those are based kind of on a case-by-case basis. Next slide, please. So for background, the effective communication FAQ document is an outgrowth of the Departments of Education and Justice joint filing of a brief in a 2012 case called KM versus Tustin Unified District and the Ninth Circuit Court of Appeals decision in that case. To give this guidance some context, I want to briefly just go through the facts of the case with you so you can keep it in mind as we go through the requirements. In the KM case, a high school student with a hearing impairment, and she had 2 cochlear implants, asked her school to provide real-time captioning so she could better hear her teacher and follow class discussions. The school district refused and provided preferential seating and class notes instead. The school argued, and the lower court agreed with the school, that the school had provided FAPE under the IDEA because the student was able to benefit from her education through the preferential seating and the class notes. The district court believed that the school only had to comply with the IDEA and that the ADA effective communication requirement didn't require anything more than FAPE. So the Departments of Justice and Education jointly filed an amicus brief when the case was appealed. We argued that the IDEA's FAPE requirement and the Title II's effective communication obligation have different requirements, and that the district court was wrong when it found that a student's rights under the ADA were automatically satisfied because the student was provided FAPE under the IDEA. The Ninth Circuit agreed with our analysis and held that the FAPE standard under the IDEA is different than the ADA's effective communication standard, and that school districts must analyze their obligations under both the IDEA and ADA. Next slide. So following the Tustin decision, ED and DOJ issued a Dear Colleague letter and FAQs to explain the rights of students with disabilities under the 3 laws, and that's the IDEA, Section 504 of the Rehabilitation Act, and Title II of the Americans with Disabilities Act. In this presentation, we'll briefly touch on each of these laws and then talk about the Title II standard, focusing on how it's different from the IDEA standards, and then we'll talk a bit about the interplay between the IDEA and the ADA and how a school district can effectively implement both laws. Next slide. So, as you all know, the cornerstone of the IDEA is the entitlement of each eligible student with a disability to a free, appropriate public education. And FAPE is provided through the provision of education and related services that are provided in conformance with an IEP and designed to meet the student's unique needs. Students must be provided with the opportunity to access and make progress in the general education curriculum. Also, IEP requirements include consideration of a child's communication needs, and we'll talk about those requirements in more detail later in the presentation. Next slide.
My name is Ann Hoogstraten. I'm an attorney with the Office for Civil Rights here in the department, and I'm going to do the next few slides. First, I just wanted to point out that there is another law out there, Section 504 of the Rehabilitation Act of 1973, and the guidance that the departments issued back in the fall of 2014 did not address, didn't really say much about 504. Just as a brief review, as you all probably know, 504 prohibits disability discrimination in federally assisted programs or activities. So why didn't the joint guidance address focus on 504? Well, as a general rule, violations of 504 are also violations of Title II of the Americans with Disabilities Act. So there was a thought that 504 would not add much more information to the guidance. And in generally, the Office for Civil Rights, OCR, would not find a violation under 504 if the school complied with the requirements embodied in Title II's effective communication requirements. As for FAPE, as you all probably know, Section 504, as well as the IDEA, has a FAPE requirement, and FAPE under 504 is defined as regular or special education and related services that are designed to meet individual educational needs of students with disabilities as adequately as the needs of students without disabilities are met, and that satisfy certain procedural requirements. And under the 504 regs, implementing an IEP developed in accordance with IDEA is one means of providing FAPE under 504. So again, there was a thought that talking about 504 separately would not add that much. And since the Ninth Circuit has focused on IDEA and Title II, that's what we were going to focus on in our guidance. Next slide, please. So I want to give you a little information about Title II. As you know, Title II, as well as 504, are civil rights laws that prohibit disability discrimination against qualified individuals with disabilities, whereas 504 applies to recipients of federal financial assistance. Title II of the ADA applies to applies to all state and local governments, regardless of whether they receive federal funds. The one part of Title II that we're going to talk about today is a requirement for effective communication, and that requires public entities such as LEAs and public charter schools to ensure that communication with individuals with disabilities is as effective as communication without disabilities. Next slide, please. To understand what Title II requires, it's important to understand who is protected by these laws. And so Title II protects individuals who are qualified individuals with a disability. Under Title II, disability means a physical or mental impairment that substantially limits one or more major life activities or major bodily function, a record of such an impairment, or regarded as having such an impairment. This is also the definition that is used under Section 504. As you might have heard, back in 2008, Congress passed the ADA Amendments Act to correct what Congress deemed an overly narrow interpretation by courts about who has a disability. And the Amendments Act clarified that the definition of who has a disability is to be construed broadly. And when determining whether an individual has a disability, Congress made clear in the Amendments Act that you should not take into account the ameliorative effects of mitigating measures such as medication in determining whether a physical or mental impairment that someone has substantially limits them in a major life activity. The other part that's key to remember of who's covered under, who is protected under Title II is this notion of qualified. It doesn't mean that you have a disability that qualifies. It rather means that you are an individual with a disability who meets the essential eligibility requirements for whatever the service is. And in the elementary and secondary context as spelled out in the 504 regs, you're eligible, a student is eligible for elementary, a student with a disability is eligible for services, eligible for FAPE services, essentially if he or she is of the correct age. Next slide, please.
So as you'll note, the definition of disability under the ADA is different than under the IDEA. And as you're familiar with, I'm sure, under IDEA, a child with a disability is defined as a child that's evaluated in accordance with the IDEA procedures as having one of the 13 disabilities listed in the definition, and who, by reason thereof, needs special education and related services. There'll be some overlap between children, whether they are eligible under both, and then in some instances it'll be different. Next slide, please.
So how do public schools meet their Title II effective communication obligations? And that's what the next several slides are going to address. Essentially, as it says on the slide, public schools must provide appropriate auxiliary aids and services to ensure that communication with students with disabilities is as effective as with other students, so that students have an equal opportunity to participate. Before we get into the substance of the requirements, I did want to flag something that are called Title II defenses. Next slide, please. These are defenses that really that a school could, or any public entity could raise in court if they're sued under Title II. And in the context of effective communication, it means that a public school does not have to provide a specific auxiliary aid or service if the school can show that providing that aid or service would result in a fundamental alteration or undue financial or administrative burden. Kind of a mouthful there. But it's essentially if the school district can prove, not the student with a disability or his family disprove, that if the school provided the particular auxiliary aid or service, it would meet the legal threshold for being a fundamental alteration or an undue financial or administrative burden. But even in real time, not later if there's a court suit, but in real time when the school's trying to figure out what a student needs under the effective communication provision, if the school thinks this is going to be a fundamental alteration or an undue financial or administrative burden, the school can't just stop there, but they still have to go forward and take other steps to see if there's another auxiliary aid or service that would not result in a fundamental alteration or undue burden. I just wanted to point out that these defenses, fundamental alteration or undue burden, do not apply to FAPE at all. They just apply to the effective communication provision in this context. Next slide, please. So then what are these auxiliary aids and services under Title II? They're spelled out in the regulation, and for those of you who are familiar with regulations, federal regulations are codified in something called the Code of Federal Regulations, and the Title II regulations are in 28 USC Part 35, not 28 CFR Part 35, and that's where you can locate the regulatory information about Title II. So auxiliary aids and services make orally or visually delivered information available to students with hearing, vision, or speech disabilities so that they can receive information from and convey information to others as effectively as students without disabilities. The Title II regulations do not give an exhaustive list of what is an auxiliary aid or service, but rather they provide examples. For instance, for a person who is deaf, deafblind, or hard of hearing, examples of auxiliary aids and services are interpreters, qualified interpreters, that is, note takers, CART, assistive listening systems, accessible electronic and information technology. For a person who is blind, deafblind, or has low vision, some examples of auxiliary aids and services could be qualified readers, audio recordings, braille materials, optical readers, and other electronic and information technology. And for a student with or a person with a speech disability, some examples could be a letter board, writing materials, qualified sign language interpreter. In general, the services, devices, technologies, and methods for providing effective communication that are auxiliary aids and services under Title II could also be provided under the IDEA as part of FAPE. And whatever a student's disability, the student is entitled to effective communication under Title II. Next slide, please. How do schools decide which auxiliary aid or services provide effective communication? There are a few principles. One is that it must be an individualized determination. For instance, a school can't just assume that all deaf students are fluent in ASL and therefore an interpreter in ASL would be appropriate. The school district has to follow a principle called primary consideration, which I'm going to get to on the next slide, so hold on to that concept. And it has to be on a case-by-case basis, not only considering the individual needs of the student, but also what the student has requested, primary consideration, the nature and complexity of the communication involved, and the context of the communication. For example, what may begin as a simple request by a student to check out a book from the school library, where if a student is deaf, perhaps an exchange of written notes would be sufficient. That can evolve into a more complex communication concerning assistance in completing a research paper. And at that point, an exchange of notes perhaps would not be sufficient. It's also important to remember that effective communication does not apply just in the classroom. It can apply throughout the school day. Next slide, please. So returning to that concept of primary consideration, which is, again, spelled out in the Title II regulation, the school must give primary consideration to the particular auxiliary aid or service requested by the student with a disability or the student's parent. This does not mean that the student automatically gets what he or she has requested. It means that the school district has to really think about whether that's going to work. If they believe it's going to prevent those a fundamental alteration or undue burden, those defenses that I mentioned earlier, they don't have to provide the request, the particular auxiliary aid or service. And if they can come up with an alternative that truly is equally as effective to provide the student with an equal opportunity to participate and benefit, then the school can provide that alternative. It's important for primary consideration to remember that the principal, that generally it's the person with a disability or his or her appropriate family member who's most familiar with that student's disability and can provide the relevant information about which aids or services will be most effective. Next slide, please. So how do you determine if a particular auxiliary aid or service is effective? There's 3 principles that the regulations talk about. The auxiliary aids or services must be in an accessible format. They must be provided in a timely manner and provided in such a way as to protect the student's privacy and independence. Accessible format is somewhat straightforward. If it doesn't work for the student, it's not working. For instance, if a blind student is not able to read Braille, then providing them with Braille materials is not helpful. Must be provided in a timely manner. That essentially means as soon as possible. The regs don't have any particular, do not articulate any particular time frame. If the student is waiting for an auxiliary aid or service, the school district or school should keep the student and parent informed of what the auxiliary aid or service, when it will be provided. And protecting privacy and independence, it's the 3rd principle. Examples of this means that don't provide auxiliary aids and services in a way that unnecessarily discloses the nature and extent of the individuals with disabilities. For instance, if the student who is hard of hearing needs assistance with taking notes, the school shouldn't call out for volunteers in front of the whole class and point out that the student can't hear well and needs assistance in taking notes. And independence, a good example of independence is that if a blind student requested an accessible electronic book, like an e-book reader, to complete in-class reading instead of using the reading aid, that e-book reader would give that student so much more independence because the student could go through the material at his or her own pace with the ability to revisit passages as needed and not just when the reader is available. Next slide, please.
So the rest of the presentation is going to focus on the interplay between IDEA and Title II and how to implement both of them. So first, how do IDEA, FAPE, and Title II effective communication requirements differ? So under Title II, the regulations require that the district take appropriate steps to ensure that communications with persons with disabilities are as effective as communications with other persons. So this is a comparison standard that Title II has. They also require that a district provide appropriate auxiliary aids and services where necessary to afford a person with a disability an equal opportunity to participate in and enjoy the benefits of the district's programs and services. Under the IDEA, FAPE must be individually designed to provide meaningful educational benefit to the child. This is not a comparison standard. IDEA does not require that a district compare the effectiveness of communications between students who have disabilities and those who don't. IDEA does, however, require that IEP teams consider the communication needs of each child with a disability and include specific requirements for children who are deaf or hard of hearing. So for a student with a disability who's covered under both laws, and this would be all IDEA eligible students who have a hearing, vision, or speech disability, the school district must ensure that both sets of legal obligations are met. For many students, the special education-related services that they receive under IDEA will also ensure that communication with those students is as effective. So they will meet both standards. But in other instances, the auxiliary aids and services required under Title II, they may not necessarily be the same as the special education-related services required under IDEA. So when you are determining FAPE for a child, you also have to look at Title II. These are two separate determinations. Next slide, please. So how are requests made for Title II auxiliary aids and services? Title II does not designate a particular person or for a parent or student to contact or a specific process for individuals to follow. The school district can determine whom the parent should contact with requests for auxiliary aids and services and other ADA issues, and Title II requires school districts to provide notice about Title II and how it applies to the school district's programs. It's also important to note that parents do not have to make a specific request for different or additional auxiliary aids and services. And when the school district knows that a student needs assistance with communication because, for example, he or she has a hearing, vision, or speech disability, the school district also has an affirmative obligation to provide effective communication under Title II, whether or not the parent specifically requests certain auxiliary aids or services. And again, this obligation is in addition to the requirement that the school make FAPE available to a student eligible under IDEA. Next slide, please. So evaluations. May information from IDEA evaluations be used when considering a Title II request for auxiliary aids or services? So Title II does not mandate a particular evaluation process. If a school district has already completed a child evaluation under the IDEA, it may rely on that information obtained from the IDEA evaluation when determining the need for effective communication under Title II. However, the school district must analyze the child's needs and how to meet those needs based on the Title II standard. That's the as effective as standard. And this will also include giving primary consideration to the request, as Anne described earlier. Also, the school district must provide the auxiliary aids or services in a timely manner, and they cannot wait for the IEP process to run its course before providing auxiliary aids and services under Title II. So in this situation, the school district must first address the child's needs for auxiliary aids and services based on Title II while proceeding with the IDEA evaluation. And once the evaluation under IDEA is complete, the school district may need to reassess at that point whether the child needs different auxiliary aids and services under Title II. Next slide, please. So how does the IEP team fit into a Title II determination? So the Title II regulations, they do not designate a particular responsible person or group of people that make the determination about the provision of auxiliary aids and services under Title II. The Title II regulations, they do require that most school districts and those that employ 50 or more people select at least one employee to coordinate the implementation and compliance with the district's responsibilities under Title II. And this person is usually referred to as the ADA coordinator. There's nothing in IDEA or the ADA that requires that the IEP team make decisions about auxiliary aids and services under Title II. However, a school district may give the ADA coordinator the responsibility for making those decisions, and they may choose to have the ADA coordinator participate in IEP reviews. So if the school district does designate the IEP team as a team to make that decision, it's important that the team realizes that they look at FAPE and they look at the special education related services needed under FAPE, and then as a separate decision, they look at the Title II standard, the comparison standard, the as effective as standard, and they consider any auxiliary aids or services that are needed to meet that standard. In many situations, they will be the same, but in some situations, as in the testing case, they may be different. Next slide. Dispute resolution is it different for Title II under IDEA? So as I'm sure you all are familiar, under IDEA, a parent can request mediation, they can file a state complaint, or they can file a due process complaint. And then regardless of whether or not the student is also eligible under Title II, a parent of a student with a disability can file a Title II complaint regarding the denial or limitation of a particular auxiliary or aid or service under Title II, and that can be filed with the U.S. Department of Education's Office for Civil Rights, or it can also be filed with the Department of Justice's Civil Rights Division. Or in some school districts, the parent can file a Title II grievance directly with the school district if the school district has such a procedure. And I believe the FAQ has more specific information on how to file these complaints. The next slide. So here are the links to the Dear Colleague on Effective Communication and the FAQ document, along with our brief and the testing case that I mentioned earlier. Most of what we talked about here are questions taken from the FAQ document, and the answers in that document will go through more detail for you. And also at the end of the FAQ document are two kind of case study hypothetical situations. One illustrates a situation where the services under IDEA and Title II are the same, and the other example illustrates a situation where they are different and how the rationale and how the decision will be different services under each statute. So that's what we have for now. If you have questions, and I can try and answer them.
Yes, there were questions that came up in the chat box, and I want to go back to the very first question that was asked, which is how would Title II have affected the Rowley decision?
Well, this is Anne. That's a good question. I don't know the answer, but Title II has a different standard. It's an equality standard, so it's not. It's framed differently from the outset. So I don't know how the court would have ruled in Rowley if they'd been considering Title II.
Okay. And let me go to the next question, which is, would school district designate on a case-by-case basis or have a designee already appointed? And I think this is a reference to who would handle Title II requests.
And this is Anne. I'll jump in here again. The Title II regulation does not specify at all. So I don't, while I don't presume to speak for the Department of Justice, I don't believe that there would be any prohibition on a school district setting up a system for how to make these determinations that involve more than one decision maker, if that helps at all.
There just has to be notice as to what that process is, right?
Right. Yes, and very good point. Thank you. The IDEA statute and regs are very detailed, of course, and have lots of information about procedures to be followed. And the effective communication regulations in regulatory provisions in the Title II regulation do not have that level of detail at all. So school districts have discretion.
Okay. If the district, this is another question, if the district does not specify that an IEP team be responsible for making decisions about auxiliary or aids and services under Title II, does it go to them by default, or does the responsibility then rest on the school?
Unfortunately, it's a similar answer that, you know, the Title II regs don't mention a specific person, so I believe default necessary to the IEP team. it could be, it just depends who they've designated, who the school district has designated to make those determinations.
Okay. This is a similar kind of question. Could the school district appoint IEP team instead of other existing designee?
Yes, they could. They could designate the IEP team to make both determinations.
Another question is, what does administrative exhaustion may apply mean in reference to dispute resolution under Title II?
This is Anne. I'll tackle that. That's a good question. So administrative exhaustion, broadly speaking, is that before someone can sue in a federal court, they have to exhaust all the administrative remedies before they go to court. Title II and 504 do not have any exhaustion requirements of their own, but the IDEA does have an exhaustion requirement, and that exhaustion requirement statutory requirement also applies to when individuals sue in federal court seeking relief that is available under the IDEA. So I think it depends a lot on what the nature of the request and the relief sought is. And there is a Q&A in the FAQ document that addresses exhaustion in a little more detail.
Great. And then the last question we have here is, can a Title II assessment be requested separate from an IEP evaluation? Is there a scenario where one would be eligible under Title II versus an IEP versus 504?
You mean where a child would be eligible under one or not the other, or that?
Yeah, I think that's what they're trying to say. Yeah.
Well, we think for children who are eligible under IDEA with speech, vision, or hearing, that they will also be covered under Title II. Now, going beyond that, there may be instances where you are eligible under one but not the other, but these effective communication requirements apply to those three, speech, hearing, and vision.
Okay. And you also mentioned that in the frequently asked questions, there's some scenarios in the back that also help to eliminate some of these issues, right?
Right. We go through most of these slides were taken as questions, so and the answers are much more detail in the document.
Okay, great. Well, thank you very much. We really appreciate this. Thanks again. And if we have any other questions, or if you all have any other questions after the call of the Parent Centers, you can send it on to your project officer and or to me, and then we'll forward them on to Anne and to Laura. Thanks again, Anne and Laura.
You're quite welcome.
Now we're going to move on to the notice of proposed rulemaking around significant disproportionality, and Jill Harris is going to address that. So Jill?
Yes. Good afternoon, everyone. Again, my name is Jill Harris, and I'm a policy analyst with the Office of Special Ed Programs. I wanted to alert the community of parent organizations, parents, and advocates to the fact that we have recently released a proposed rule for comment that focuses on significant disproportionality. Hold on.
No, you don't let Carmen know.
You can change to the next screen, Carmen. Before I get started discussing the content of that notice, I wanted to make sure we all had a ground level understanding of what significant disproportionality is. And I have provided on this screen, on this slide, a little language to help us focus as I walk through the rest of the slides. Significant disproportionality occurs where districts identify, place outside the regular classroom, or discipline children from any racial or ethnic group at markedly higher rates than their peers. Next slide, Carmen. Now, Congress has been concerned about the high number of students from minority backgrounds that have been referred to special ed since the 1997 regulations. That's when they first started writing language and regulations regarding this issue. However, in the 2004 amendment to the IDEA, Congress very specifically made some regulatory changes and added very specific language about what they expected a state to do when significant disproportionality was identified and what would happen as a result. And on this slide, I wanted to bring out two facts. One, that even in the 2004 amendment, states had a discretion on how they measured significant disproportionality. So that means whatever way they came up, whatever methodology they used to say that a district did or did not demonstrate significant disproportionality, from state to state, that could and did vary. The other thing that was allowed in the 2004 amendment was that if a district was identified as demonstrating significant disproportionality, that district would be required to set aside 15% of their IDEA Part B funds to provide, hold on, I'm trying to get my system, to provide what we call comprehensive coordinated early intervening services, which is CEIS, to children in regular education in grades K through 12. In addition, if the district was identified, that district had to review all of their policies and procedures related to the identification, placement, and disciplining of children. And if they had any issues that they identified, they had to make those issues publicly available on the state website. So that was in 2004. Next slide, please, Carmen. In 2013, looking at state-reported data, we found that in a nation of over 13,000 school districts, only 491 districts were identified by states as demonstrating significant disproportionality, which is about 2 to 3% of all districts. And of those districts, of course, once they identified, they had to transfer the CEIS money and review their policies and procedures. Next slide, please, Carmen. At this time, the department is proposing a change in the current regulations regarding significant disproportionality. One change that we are proposing is that states use the same methodology to measure whether a district is demonstrating significant disproportionality, and that they use this method to identify significant disproportionality in the identification, placement, or disciplining, including suspensions and expulsions, of a child. We're also asking in the proposed rule that the CEIS funds that were originally only for children without disabilities in grades K through 12, we are asking in the proposed rule that we broaden and expand the use of those CEIS funds to include children with disabilities and children with and without disabilities that are in preschool ages 3 to 5. Next slide, please, Carmen. Now, the overall goal of this proposed rule, the intent is not to limit services for children with disabilities who may need them. Rather, the purpose is to ensure that children are not mislabeled and receive appropriate services. So in other words, we want to improve our insurance that children who need services are getting them and they're getting the right services. The right children getting the right services. That is our goal. Now, what can you do? Now, next slide, Carmen, I'm sorry. Now, as parent organizations, if you have not seen the proposed rule, it is available for comment, and it includes a lot of technical information, a lot of about measurements and what measurements states have been using, what measurement we're thinking they should use. But there's also a lot of good information in there about the use of the CEIS money and how we would like to target that money, have the state target that money to focus on those specific populations that may be creating and causing the significant disproportionality. Something that you might want to be aware of is that within this proposed rule, there are 13 what we call directed questions. And of those 13, I chose 3 that I thought you might be particularly interested in because we are seeking comment not only as to the entire proposed rule, but in addition we're seeking comment to these 13 directed questions. And one of those questions that you may be interested in is what TA should be put in place to prevent under-identification of students to avoid designation of significant disproportionality. In other words, what if a state says, well, I don't want to be identified, so maybe I just will not identify kids in this ethnic group and in this disability category. We'll just send out a secret policy that says, don't identify. What if a state feels they're in that position? What we're asking in this question is if a state should feel that way, what kind of TA do you think the department should put in place to support states to give them an incentive to identify significant disproportionality when it is appropriate to do so? The second directed question you may be interested in is whether there should be restrictions on how the CEIS funds may be used with children that are already receiving Part B services. So in other words, these funds that have this 15% of Part B money, if it is going to be used, if the state decides that yes, this district has been identified and yes, you have to transfer this money, if the district decides to use the money to focus on special ed kids, a large amount of the money, they can't use all of the money on special ed kids, but what if they decide to use some of that money on special ed kids? What kind of restrictions do you think may need to be in place to guide special ed departments on how to use that money to improve services for kids? The third one I thought you might be interested in is if this regulation goes through, how should the department measure the impact of this regulation? So if this regulation goes through exactly as it is written or with modifications, how will we know if it's effective? We're looking for comments and ideas from the public across all 13 of these questions, but I thought you all would be particularly interested in those 3 directed questions. Now, next slide, please, Carmen. What I hope you do with this information, because the NPRM has already been released, and it will be out for comment until May 16th, is to share the NPRM with others who you think may be interested, and I'm talking about everyone, universities, advocate groups, other parent groups, any kind of group you think would be impacted by this rule. And I hope that within each of your states you stay tuned for any state and local discussions regarding significant disproportionality, because remember, the regulation has been on the book. The original, the current regulation there is a current regulation already on the books, and it's been there since 2004. So your state has been applying some kind of measurement since that time to identify children are districts who may be demonstrating significant disproportionality. So in your state, has your state found any districts that demonstrate significant disproportionality? And if so, what has happened? So those are the kind of things you can start thinking and discussing. And the other thing is to be sure to comment on the rule. Next slide, please, Carmen. Now, as I said, the rule is open until May 16th, 2016 for comment. And any comments you may have can be, you can put them in on site at regulations.gov. It's real simple. You go to regulations.gov, put in significant disproportionality in the search engine, and it pops right up and tells you how to put your comment in. It's a very simple process. So I appreciate this opportunity to discuss and tell you all about this, and hope that you take the time to read through it and share it with your colleagues and provide us comments. We're really looking forward to seeing what the comment says, the public is saying about our proposals. Thank you.
Thank you, Jill. There's 4 questions that came through in the chat box, and I'm going to just read them in case you can answer them. Does preschool mean public preschools?
Okay. We're talking about, okay, let me just say this. We're talking about 619, 3 to 5-year-olds that are eligible for IDEA. The reason I'm hesitating about public preschools is because some 619 programs use private child care sites and other settings for 3 to 5-year-olds. That's why I hesitated. But we're talking about any child eligible for IDEA under 619. That's who we're talking about under preschool.
Okay. And then the other question is, can you clarify what is meant by standard methodology?
Well, let me say this. A standard methodology, what we're proposing is that states use the same way of measuring significant disproportionality from state to state. Remember earlier in my presentation, I said that the current regulation allows a state to use their own discretion, which means Mississippi is measuring one way, Vermont is measuring another way, California is measuring another way. What we're trying to do is standardize that measurement to a large degree so that we can not necessarily compare, but that we have more validity and reliability around what we're calling significant disproportionality.
Thank you. The third question was, is there a resource that you can share that analyzes the different methodologies currently being used from state to state?
That is an excellent question, and if you read the proposed rule, that is already in there.
Oh, okay, so it's in the proposed
yes, it is. We did a lot of data analysis around this. We reviewed what other states were doing. We present all of that in the proposed rule.
Great. And then the last one was more of a comment, which is the states and districts need TA on how if CEISS funds can be blended or braided with Title I funds to address the significant disproportionality. So that is more in the nature of a comment, but that's the kind of, maybe the kind of comments you want to hear in the... That
is exactly what we would like. Yes, you're exactly right. We would love that comment in regulations.gov. But let me tell you that we have already begun to discuss guidance that the states and the public will need as this proposed rule moves forward. And that is certainly something that we would probably write about and provide guidance on.
Great.
But please put that comment in on the website. That is an excellent comment.
Well, thanks again, Jill. And we're already at an hour, and this is going to go over, but I just want to switch over now to Al Jones. We'll talk about the self-assessment for correctional ed. And again, thank you, Jill.
Thank you.
So, Al?
Hello, everyone. My name is Al Jones. I'm Associate Division Director in the Monitoring State Improvement Planning Division, and I'd like to review the self-assessment and review some of the guidance that's been released by the department. Next slide, please. In 2014, the department released a correctional education guidance package. The Dear Colleague letters highlight the IDA regulations that apply to students with disabilities in correctional facilities, laws that apply to juvenile justice residential facilities that receive federal funds, and how students in juvenile justice settings can access Pell Grants. In addition, the package includes guiding principles for providing high-quality education and juvenile justice secure care settings. If you'd like to review the full text of these 3 Dear Colleague letters identified on this slide, you can go to the department's homepage, which is www.ed.gov, and in the search box, enter the title of this slide, which is 2014 Correctional Education Guidance, and the search will return a link that will take you directly to the Dear Colleague letters. Next slide, please. This slide highlights the guiding principles OSEP uses when working with states related to education and juvenile justice secure settings. The 5 guiding principles highlighted focus on a safe and healthy facility-wide climate, funding to support educational opportunities for youth in juvenile justice settings, having qualified educational staff in these settings, providing rigorous and relevant curricula along with state standards, and formal processes and procedures to support the educational navigation of youth in juvenile justice settings and their reentry back into their communities. Next slide, please. A youthful offenders are served in numerous public agencies as they work their way through the juvenile justice and adult correctional system. These agencies may include courts, social service agencies, detention centers, group homes, rehabilitation programs, and social programs. When schools are not informed that youth are incarcerated, information about special education needs are not transferred. Even when schools are informed of incarceration, IEPs and other pertinent information may not be transferred because of poor or inadequate coordination within the school system. This presents a problem for correctional facilities because resources needed for their assessment of youth typically are not available at the facility. A lack of guidelines or written procedures for the exchange of information regarding, for example, notification of incarceration or exchange of records, for example, interferes with the transition of students in and out of correctional facilities. Correctional education programs that serve a large region or a whole state are further challenged by interagency coordination because this necessitates working with personnel and procedures from multiple schools and agencies. Next slide, please. The department has developed a state correctional education self-assessment tool that can be used by states. The SCES is a voluntary tool that was developed by OSEP to assist states in assessing their system for providing special education and related services to students with disabilities in correctional facilities. The self-assessment tool was not designed as a monitoring document, but as a tool for assisting and providing technical assistance to states. Next slide, please. The self-assessment document is organized into 3 main areas. The first area highlights requirements for interagency agreements between SCES and other public agencies. The second area provides a tool to evaluate and track state's progress in addressing state and SEA's responsibilities to students with disabilities in correctional facilities. The third area provides a tool to evaluate and track how the IDEA requirements are being addressed by public agencies in states, including LEAs, correctional facilities, and correctional facilities that operate as LEAs and non-educational public agencies. Next slide, please. Welcome to take questions on anything. And the one thing I do want to highlight is that the correctional education package that was released in 2014 has a wealth of information. So that's a great place to start if you want additional information on this topic.
Thanks, Al. There's a question in the chat boxes, and the question is, are guidelines available to help parent centers identify best practice in collaboration with correctional facilities and working with families? Does this self-assessment ask LEAs or invite LEAs to partner with parent centers?
That's it. The first part of that question, the IDEA Dear Colleague letter does highlight best practices that may be useful for parent centers. The assessment tool specifically targets the requirements of IDEA related to students with disabilities. So that may also be helpful for parent centers.
Okay. I don't see any other questions related to correctional facilities. And you said that the way that they can pull down the entire package is by going to www.ed.gov and then typing in 2014 guidance on correctional facilities. Is that right?
Yes, yes, and it will come directly up.
Okay, great. So I think people may want to have a chance to sort of look that over and then see what's in there. There were some questions related to our first presentation on effective communication, and I don't know if, let me see, it looks like Laura and Ann are still here. Let me go back up to those questions, and maybe you could address some of those. I'm looking for them right now. All right. I'm looking for them right now.
Okay.
The question is, would this apply to students with neurological disorders that cannot access instruction due to interference with attention, such as ADHD?
Yeah, we've asked that same question. You know, Title II doesn't use the same definitions that we use in IDEA, so it's whether it's, you know, a speech, vision, or hearing. So we need to fall under that. I know Anna, if you want to talk about the Title II interpretation of speech disability, of what we decided.
Yes, this is Ann. I think the bottom line that is if a student with a disability has difficulty communicating, they're entitled to effective communication. So I don't want to get too far into the weeds on that because the weeds are a little bit controversial, but that is the bottom line.
Great. Thank you. And then the last question on that is, what if the school district does not designate a specific person to be responsible, even though they're supposed to do so?
This is Ann. I'll have a go at that. If the failure to notify a person results in students not being able, students with disabilities who have problems communicating don't get the effective communication that they need, that's a problem. There's no particular, as I said, there's not a process mapped out, so it's hard to find a procedural violation. I think it's safest just to look at the end result. And it seems to me if you don't tell people how to request these effective communication auxiliary aids and services, and you don't tell them who to go talk to, then how on earth is the parent supposed to figure it out?
Right. Okay. I also just want to draw your attention to one of the links that Ann and Laura had probably changed since they put together the PowerPoint. And there's a revised, in the answer, there's a revised link. It does redirect you if you go to that link. It directs you to the newest one. So with that, I want to thank very much our panelists, Ann and Laura, for talking about effective communication, Jill about how we can, all of us can comment on the notice of proposed rulemaking around significant disproportionality, and now Al about the new guidance and also the self-evaluation, self-assessments around correctional facilities. I think all of you in the parent centers would want to look at that and see how that can be used to inform your work and the work that you provide to your families. Even as I said that, we had one question on the correctional facilities piece out, and it just came in from Ann Smith. Does the guidance for correctional institutions extend to secure residential facilities that are managed by children's departments other than judicial or correctional agencies? Al may still be on mute.
I am. Sorry about that.
Oh, there you go.
If it's a
Okay.
public educational agency federally funded, it does.
So if it's funded publicly, it does apply to them also?
Yes.
So what you just said. Okay, great. Thank you. So again, thank you for our presenters. I want to remind you, we do these calls quarterly. It's almost always the third or the fourth Thursday every quarter. So the next time will be sometime in June. Thank you all for participating. Once we get a link up and all that, I will send that information as to how you are able to be get the recording and listen to this again. And those of you who had trouble downloading the handouts, please work with your regional TA provider, and I'm sure we can work out a way that you can get the PowerPoint. So thanks again, everybody. Thank you. And I think you can stop recording now. Thank you.